All right, so let's talk about RPC 4.2. All right, I'm going to read a little bit of this right to you. All right, so the deal is it's the communication with a person represented by counsel. Already you could tell that's loaded. So let's go through it. In representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows. Think about that. The lawyer knows to be represented by another lawyer in the matter unless the lawyer has consent of the other lawyer or is authorized to do so by law or a court order. All right. This is so important. It's so dangerous. So when you have the former employee, if you even think that they are what we would call, air quotes, I hate to do that, but fair game, okay? If you think that someone is fair game to have this conversation with, there's a lot you have to do. Inclusive of this conversation is to make sure that that person doesn't have a lawyer, to make sure that the person is comfortable speaking with you. But there's a large hurdle before we get there, okay? When you look at RPC 4.2, if you read that, it does not tell us what it means to be represented by another lawyer, and it doesn't even talk about litigation control group, but I'm telling you, when you get into it, when you get into the case law, it does talk about litigation control group. What this also means is that in the wild and frenetic day-to-day practice of law, you need to be ready because it will happen. Your phone will ring and one of your staff members will say, I have John Smith on the phone who used to work at Acme Nursing Home, and John Smith wants to talk to you. If you don't know the case law, you don't know how to deal with that. If you don't know the RPCs, you don't know how to deal with that. If you don't deal with it properly, there's two potential negative fallouts. One, you might do poor for your client. In other words, you might not serve the interests of your client by properly availing yourself of potentially helpful testimony. The other thing you might do is lose your license to practice law. So, what do? First, find out, not through a direct conversation, but either through your staff member or maybe from the chart, what is their employment status? And by the way, it's not the only thing to look at, but it sure as heck is an important thing to look at. Then take a look, pull out RPC 4.2, not the American Bar Association version, but your RPC for your state. Okay, that's important. All right, now the next thing, which I alluded to before in my Pennsylvania example, find out what, if anything, that person's role was with regard to your case, and this is why. There are former employees who have a lot to say about the nursing home in general. This was a great place. This was a horrible place. We had enough staff. We didn't have enough staff. We didn't feed the residents. We fed them a lot of money. There was always talk about filling beds. There was all sorts of pressure to fill the beds. There's all sorts of things they could be talking about. Or they could be talking about your client and your client's injuries or your client's mistreatment specifically. In case by case, or in different jurisdictions, in a case-by-case analysis, whether or not they play a role as a fact witness in your case as opposed to a fact witness with regard to the facility is critically important because it might matter where you practice. Don't talk to the witness. Don't have any conversations until you figure out what's going on. Now, I can tell you in New Jersey, we actually have somebody we can call. We can actually pick up the phone and we can ask an ethics question. So if you have a close call in your jurisdiction, you could look into it, talk to your colleagues, run it by other folks, get somebody to write a memo. And I know in the reality of day-to-day practice, from the plaintiff's point of view, you're very worried that that witness will get away from you, or, as we'll talk about, the defense might get to him or her. So either way, you'll feel the time pressure, but take a deep breath and spend some time on this issue because there's too much at stake not to. When you find yourself wondering, hey, should I do this? It seems like I probably can. Don't. If you have any question at all, remember that old appearance of impropriety. The same applies with formers in nursing homes. If you feel like contact with that witness even slightly pushes the envelope with regard to the propriety of having that conversation, just don't do it. And this is what I tell lawyers all the time. If you're on the fence, if you feel like it's very gray, don't push it. Send a subpoena and take the deposition. And then you will worry every day between when you serve the notice of the deposition, the subpoena of the deposition, And the day of the deposition, will the other team get to this person? And they sometimes do. And that's life.